tenancy relationship. That's the relationship between two individuals where one person gives his property out to another person, that is the tenant, to occupy or to take possession for a period of time and for a particular amount, which is which is called rent. So today we're going to be talking about the procedure of the landlord retaining possession of the premises. But before we go further, let's discuss the various types of tenancies, because this could help in knowing the procedure or giving notice for determination of tenancy agreement. So the first type of tenancy is tenancy at sufferance. This is where a tenant who initially had lawful possession of the premises is now in default, in the sense that he no longer owes possession because time has either expired, but he is still in possession of the premises without the consent of the landlord. Another type of tenancy is tenancy at will. This is also similar to tenancy at sufferance, where a person who has had lawful possession of premises no longer has so, but is staying in possession, is still presently in the premises, but with the consent of the landlord. So the difference between a tenancy at sufferance and a tenancy at will is the fact that tenancy at will, the consent of the landlord is given to that tenant. A tenancy at will, even though his time or tenancy agreement is up and he is no longer required to be in possession. Another type of tenancy is periodic tenancy. This is the one that is determined from time to time, probably weekly, monthly, or yearly. Then there is tenancy for a fixed period. This is where the date of commencement is fixed and the date of determination, that's the date that the tenancy is supposed to end, is fixed and agreed by the landlord and the tenant. And then there is the statutory tenancy. This is where a person owes premises after his tenancy. This is where a person still owes possession of a premise after his tenancy has expired, but is protected by law. Then another one is service tenancy. This is, for instance, a person giving accommodation in his official capacity. For example, government workers who stay in government quarters. The person owes possession of these premises for as long as his service is still in service with the employer. So we've said 6 types of tenancy. The first one is tenancy at sufferance, tenancy at will, periodic tenancy, tenancy for a fixed period of time, statutory tenancy, and service tenancy. So now that we know types of tenancies, let's talk about the grounds, like reasons why would a landlord want to evict a tenant. Why would he want to take possession of the premises again? So some of the reasons or grounds as to this could be arrears of rent, where you, the tenant, has refused to pay your rent for about 6 months if it's in a yearly tenancy agreement, for about 6 months or more, for a long time. Once that is being done, where you have failed to pay your rent, the landlord has the right to evict the tenant and reclaim possession of the land. Another reason for that could be where tenancy has been duly determined. That means your tenancy agreement, the tenancy period is over, it's time, the date for the tenancy to end has come, and you are still in possession. The landlord has the right to evict you and to recover possession. Another reason is where there's a breach in the express agreement. So tenancy, landlord and tenant relationship is bound by agreements in the tenancy agreement. So where you, a tenant, breaches one of those agreements, the landlord has a right to evict you and to recover possession of the premises. Another reason is where the tenant is guilty of constituting nuisance, or where the premises is overcrowded and it is not healthy, or it is dangerous to human life or property. The landlord has a right to evict tenants and to recover possession. Also, where the land or premises require substantial repairs, and where the premises has been abandoned. For example, the tenant has not occupied the particular premises property for a very long time. The landlord can recover premises in that case. So now let's go to the procedures. So now that we understand the reasons and maybe grounds as to which a landlord can recover a premises, we have to now talk about the main thing we're here for, the procedure. I need to understand that these procedures are very important. If one is skipped on one is not done, is not followed strictly, it could nullify the whole procedure, and the tenant can or could possibly sue the landlord for evicting him. So yeah, let's talk about the procedures for this. And the first one is notice. No, let me list it out for you first, so then we can pick it one by one. So the first procedure is to serve the tenant a notice to quit. That's notice to quit. Then the second step is to serve a notice to the tenant of owner's intention to recover premises. After serving this, the landlord can then institute a proceeding in court. That means he can commence an action in court, and trial goes on and judgment is given, enforcement of the judgment, and eviction is done. So the first procedure is service of notice to quit. This is a notice to quit is a direct and precise notice given to the tenant, informing him that his tenancy has been determined, therefore he needs to leave the premises. This notice is very important in the sense that you as a landlord cannot remove or evict a tenant without giving notice, and that notice is called a notice to quit. And you need to understand, just not anybody may issue this notice, and it can either be issued by the landlord or an agent. An agent in this sense could be a person who has the authority of the landlord to act on his behalf, which could possibly be a lawyer. So basically, for a lawyer or a person to have an authority to act on behalf of the landlord, he has to have given the person a letter of authority. That is, it has to be written that I hereby give Mr. the power to act on my behalf. So only persons that have that authority or the landlord can give a notice to quit to a tenant. So if you have been given a notice to quit, if as a tenant you've been given a notice to quit and it is not from the landlord or an agent of the landlord, that notice is invalid and cannot be used against you. So now the length of notice, this is very important, as it is the length of which a notice can be given to you. Okay, let me explain it in this sense. The length of notice is vital because it tells the tenant the time between which he has to evacuate, and this is usually done before the determination of the tenancy agreement. That is, if I have a yearly tenancy agreement, that is, every December my rent is due and I have to pay or I have to leave, and the landlord wants to give me a notice. He has to give me that notice way before that time, and each tenancy agreement determines the type of the length of the notice that will be given to quit. The The length of notice can be determined either by an agreement between you and the landlord, that is prior to your contract. You can determine the length of notice you would like in case a notice of quit is to be given to you, or it could also be determined by the law. This is where types of tenancy comes into play. So according to the law, a tenant at will or a weekly tenant can be given a week's notice, that is 7 days of quit, or a monthly tenant can be given a month's notice, whereby a quarterly tenancy can be given 3 months notice, and half yearly tenancy can be given 3 months notice as well. Then a yearly tenancy can be given 6 months notice. And this notice is, like I said, should be done before the ending, meaning it's the counting the date at which the notice should be given should be counted months, should be counted exactly 6 months before the determination of the tenancy agreement. Meaning, if I'm so, like I said, if my the date for my determination is 31st of December, it should be given to me 6 months before that 31st of December. If it is a weekly tenancy, it should be given to me 7 weeks before, and if it is a quarterly, it should be given to me 3 months before. And I hope you understand this, because this length of notice plays a vital role in the procedures for recovering possession of premises. And the effect of this notice is that once it is served and it expires, it automatically terminates your tenancy agreement. That means immediately you've been served that notice and it expires, you are basically no longer a tenant. The tenant and landlord relationship ceases from that moment. And if you still do not evacuate the premises, the landlord now has the right to further give you a notice for intention to recover premises. Note that the first one was notice to quit, that is notice for you to leave, that is notice to tell you that your rent is going to end. Now this one, the next one, is a notice for the recover, is a notice to recover possession, and this is usually given for 7 days. This is where the person has refused to evacuate the premises after giving notice to quit. He now has 7 days notice that for the landlord to recover the possession of the premises. And if after the 7 days the tenant has also refused to leave, this is when the landlord has the right to commence an action in court. And but it's important for you to note that these 7 days must be strictly followed. An action cannot be commenced a day before the end of 7 days. It has to be commenced after the 7 days, not before the end of the 7 days. And after this is done, the commencement of an action goes on, where parties are heard. The landlord and the tenant are heard in court, and the court determines, and the order for evacuation is given, and it is enforced by the landlord on the tenant. So basically, those are the procedures for recovering possession of premises by a landlord. The first one is notice to quit, that is notice that your tenancy is being determined. And the second one is 7 days notice for intention to recover premises. That means the landlord has said that I've given you the notice that for you to quit, but you haven't quit, and now I am giving you a notice that you have 7 days to leave the premises. If you do not do this, I will commence an action in court, which is the next step, where an action is commenced in court. And after that, a trial is set and the parties are heard, and after that an order is made and it is enforced. So like I said earlier, these procedures are very important because non-compliance with this could nullify the whole procedure, and a tenant, like I said, could sue the landlord, and the landlord would be liable. I hope today we've been able to learn something new and we understand the importance of the procedures for recovery of premises from for recovery of possession of premises. I hope you have a lovely day.